tribunals in National Judicial Data Grid, which is the monitoring tool, my lord.
We give you permission to move the Department of Justice because,
my lord, we inquired it from the Department of Justice. They say that there is no currently any proposal pending for pending consideration for inclusion of the tribunals, my lords. My lords, it will serve a great purpose. It will bring transparency and expediency, my lords. My lord's observation, my lord's direction would help.
The NJDG is part of the e-courts project.
My lords.
Now, the e-courts project comprehends only the district courts, the high courts, and the Supreme Court. We don't look at the tribunals as part of the e-courts project at all. Now, whether there should be a separate NJDG for the tribunals, etc., is a different thing. But this NJDG, this is really a mission project only involving the district courts, the high courts, and the Supreme Court. We can't expand the ambit of that because the funds will not be adequate. For instance, in phase 3, we have got 7,000 crores as a budgeted allocation for the court system. It doesn't cover the tribunals. The tribunals are not part of this at all.
Once my lords make issues directions, the funds will be arranged by the ministry. My lords, ultimately it will bring a landscape change. We will be able to.
You are not saying, you are not brought a petition to the effect that all the tribunals should be brought under the fold of the e-courts project. NJDG bring them. We can't, because NJDG is something which was developed for the e-courts project. And that covers now, phase 3 covers all the sports system properly.
My lords have issued directions for virtual hearing of by the tribunals. Ultimately, the Digital India Mission. We will be able to know.
The moment we say that the tribunals will be brought on, then the funds which have been allocated by the government of India for the e-courts project will be distributed to the tribunals.
My lords may always issue direction that additional funds should be allocated. Ultimately, it will bring greater transparency. We would be able to know how many cases are pending at which.
Done in a manner according to law. This is a project with a completely assigned budget. It's been a project which has been run since 2007. It's chaired by a judge of the Supreme Court. It's a collaboration between the Supreme Court and the Department of Justice. It covers the court system. Tribunals, you may have a case that there has to be greater transparency in the tribunals, but it can't be part of the e-courts project. Today, there is no administrative sanction for the e-courts project.
My lord, ultimately, all tribunals are subordinate to your lordship's court, and whatever directions will be issued, the government is bound to comply with them, and it will bring greater transparency, my lords.
It's got in the PI for all tribunals into the National Judicial Data Grid cannot be issued as it stands. It's of the NJDG is part of the e-courts project, which is a distinct administrative project in terms of the government of India. The petitioner would, however, be at liberty to pursue any of the affairs which he has by adopting suitable within that. Which is according to
Once we move before the government should consider it.
this would be also at the case of yes.
Greatly obliged.
My lords, I'm appearing for the petitioner Indian Qanun, which has been directed by a division bench for removal of a judgment. My lords, there are three short points.
How are you affected actually by the order for redacting?
My lords, it's not an order for redacting. It's an order for removal of the judgment itself completely. Whereas the writ petition only prays for redaction of the name of the respondent number one and the personal details. The second issue is that the direction is only...
I'm for the respondent, ma'am, please. I'm for the respondent. I'm for the respondent, 1 minute.
The respondent?
For respondent, private respondent, Lord.
Yes.
For the respondent, private respondent.
You see, you have been acquitted of a criminal offense.
Yes, my lord.
Because you were acquitted of that offense under 376.
Please, ma'am.
379. For 376, exactly.
379, whatever it is. We are looking at the principle. He is you are India Qanun.
Yes, ma'am.
Now, he uploads his judgments on the website. Assuming you have been acquitted, how can the High Court direct him to pull down the judgment?
And only me, no other reporter.
So your judgment would be, forget all that. That's one aspect, that that judgment is carried by all other reporters. Once a judgment is delivered by a court, it's part of the public record. How can anybody direct that the judgment should be pulled down? Say we entered criminal appeals. Understand the point. We entered criminal appeals. Some appeals we may convict the accused, some appeals we may acquit the accused. Once we deliver the judgment, it's a judgment which is part of the public record in the state.
My subject.
In a given case, the court may say if a child, there's a case of child sexual abuse, we always say redact the names of the victim, redact the names of the witnesses or whatever. That's the jurisdiction of the court. Or mask the names or the identity. But to say that the judgment will be pulled down is very far-fetched, because then people are saying that, look, my commercial secrets are involved. There's an arbitration case. Pull down the judgment in the arbitration case. That is very serious ramifications.
My submission, Milad, the respondent in the appellant hearing, the petitioner is free to circulate the redacted judgment, which is available on the website, Milad. And for some part, unredacted judgment is available in e-court. That is not available for the petitioner for circulation, Milad. Redacted judgment is available in the website.
My lords, there's a small problem in
and
this.
And the further matter, Milad, the cause title goes on stating the name of the petitioner who is supposed to maintain the name of the respondent.
It will then emerge that, well, you are acquitted of the offense.
My lords,
suppose in a given case somebody is convicted, all right, and the person serves out the imprisonment. That doesn't mean that he will get the judgment pulled down from the website.
No, it's very clear. The judgment is available the redacted judgment is available for publication. The friend, my learned friend, may advise his client to publish that judgment, redacted judgment.
But then that order you should have obtained from the criminal court which submitted you.
Please.
That was a contention before. That was a contention. That was a contention.
Of that order, then any publisher would be justified in saying, "I'm publishing the judgment as it is." If he has added to the judgment, we'll haul him over the court. But he's entitled to publish every judgment of a court as it is.
My lords, if I may advance a small point. My lords, I as Indian Kanun remove several judgments, my lords, from the index of Google. My lords, I'm not obligated under statutory direction or even orders by courts, and these are in categories of matrimonial disputes, personal disputes. So we take our responsibility very seriously, that we should not give wide publicity to people and their domestic problems being aired or being coming up in the first few results. But this case has been filed, my lords.
So in the case of, say, what do you do in the case of, say, family issues or divorce?
Same, my lords. That is within my case removal policy. I remove it from Google, and if a court before whom a personal dispute or a child custody or a POCOSO dispute is there, and the court has inadvertently mentioned any personal details, we still remove it. We do it when there is a statutory obligation or a direction by a court before whom a proceeding has been pending. My lords, this case is distinct from these categories, and it is emerging with emerging regularity under a right to be forgotten, which has no ingredients and is acting as a right of erasure. We have approached this court after time, after several litigations which are resulting in contradictory judgments. My lords, there's a judgment of the Kerala High Court which holds there's no right to be forgotten. There's a judgment of the High Court of Gujarat says there's no right to be forgotten. And now there's a judgment of the Madras High Court which says there is a right to be forgotten.
Take the reverse case. Can a person, suppose somebody has been convicted of an offense under section 467 of the Penal Code.
Please.
That person suffers the imprisonment. All right? And ultimately has served out the imprisonment.
Yes, my lords.
Can that person come back and say, now the fact that the judgment is born on the website of the Supreme Court or of any other high court,
yes,
is people know that he was convicted and sentenced, now pull it down. It's a public record.
My lords, here there is some indication given in Justice Call's opinion in the case Puttaswamy judgment. He draws from the European law.
The private respondent is denied of Australian citizenship because of the reporting of the judgment, Miller. The petitioner was supposed to remain the
My lords, even this judgment of acquittal, my lords, there's a genuine question of law which is emerging from contradictory judgments from different high courts. Please, my lords, require some consideration.
Is there a similar matter pending that Alka Mahindra?
My lords, I'm appearing in that matter as well. Please, my lords, add it to the Alka matter.
Thank you to the Alka matter. In the meantime, the direction concerning the Indian judgment remains clear.
Please, my lords, deeply obliged. Ma'am, my lords, there's some delay of 36 days.
The notice counter will not close. Yes.
Please.